Hi there, everyone. My name is Monica, and I'm the bilingual legal advocate with the Family Trees Legal Advocacy Program. This morning, I'm going to cover the topics of divorce and custody, how to file them, and what steps to expect after filing. Please know that I'm not an attorney, so I can't give any kind of legal advice. This will be a legal informational video. And also know it's important to know that before you file for divorce and custody, there is a charge associated with both. Filing for divorce costs around $230. Filing for custody is around $220. So just be aware of those costs. If you feel as though you're unable to pay those costs, there is a fee waiver form available online, and I will give you the information on how to access those online forms in just a little bit. So first, let's talk about what paperwork you're going to need to file for divorce. In divorce, for your information, is called dissolution of marriage here in Colorado, so just be aware that that might be on the title of some of these forms. First, to file for divorce or dissolution of marriage, you'll need JDF 1000. You'll also need JDF 1101, JDF 1102, JDF 1102A, and 1102B. Please know that all the JDF 1102s, so A and B, the only part you're going to have to fill out is the top caption box, so where it says county that it's filed in, petitioner, respondent, and the attorney information or party without an attorney information. For custody, or otherwise known as allocation of parental responsibilities, you will also need JDF 1000, you'll need JDF 1413, JDF 1414, JDF 1414A, and 1414B. Same goes with that paperwork. All of the JDF 1414s, including A and B, only fill out that top caption box. So once you file that paperwork, you're going to finish that paperwork. You're going to go ahead and file that with the court clerks in whatever county that you reside in. We work through Jefferson County, but if you're looking to file in another county, you're absolutely able to do so through a different legal advocacy agency can help you provide information on how to do that filing in any other county. Once you file that paperwork, your case is going to be created. That means, the clerks will take it back, they'll assign you a case number, and once they're done doing all of that, they're going to hand you a packet of paper called your case management order. That packet of paperwork is really, really important, and I generally encourage people to read that from front to back, to take notes, to highlight on it, and to ask any questions that you do have about that case management order. It's going to be kind of a roadmap for the next steps in your case. It'll give you information on the paperwork that you're going to have to file for your next steps. It'll give you information on how to set up mediation, how to do a parenting class, which are all required as part of your case. So do make sure that you're taking notes and reading that paperwork very, very carefully. On the front of that case management order is going to be a highlighted date and time. That's going to be the date and time for your very first appearance for this divorce or custody case, your initial status conference. So a couple of things with the initial status conference. After you file your divorce and custody case, you will have to get that packet professionally served on the party whom you're filing against. What that means is, you'll have to find someone to give them that paperwork and fill out a return of service showing that they received that packet and that they've been made aware of the case. Most people do so through the sheriff's office, but you can do that with anybody over the age of 18 who's not a party to the case, or a private process server as well. Hopefully that return of service will have been filed with the courts before that initial status conference, and the other party will also have a right to appear at that initial status conference, given that they have been given notice of that status conference. The status conference is a mostly informational, administrative conference that's going to give you the chance to learn about deadlines for the rest of the case, talk about all of the next steps for the rest of the case, and just to give you information just about what to expect going forward. I generally recommend that clients do have a copy of their sworn financial statement and certificate of compliance, at least a draft of that paperwork done before the initial status conference so that the family court facilitators can look over it, make suggestions, and kind of just see that, you've been working on the case. That being said, all of the information on all that paperwork, again, is going to be in the case management order, and instructions for the initial status conference will also be in there. So again, really look over that packet. Also, at the initial status conference, they're going to ask you if you're interested in filing a motion for temporary orders. People generally do that if they do want some kind of temporary relief from the courts on issues such as custody, payments, alimony payments, maintenance payments, allocation of property, who gets to stay in the house. All of those kind of things can be ordered or made. The judge can make a decision on those on a temporary basis through a temporary orders hearing. So if that's something that you're interested, that'd be another thing to bring up at the initial status conference. You also will be given information on how to set up your mediation, which will be mandated by the court, and your parenting class at that time as well. The case will eventually be finalized with what's called a permanent orders hearing. So all of the issues that you haven't been able to figure out through all the paperwork that will have been shared between you and the other party, such as financial disclosures, all of that information that you will have shared through mediation or through any other agreements that you may or may not have come to throughout the course of the case. Any issues that still need to be decided will be worked through at that permanent orders hearing. Once that permanent orders hearing is completed, you'll have your finalized decree of either dissolution of marriage or allocation of parental responsibilities. You will have finalized parenting plans, finalized decrees on things like payments. All of that will be finalized at that permanent orders hearing, and you'll be done with your case. Please know that filing for a divorce or custody is going to be a large time commitment. There's a mandatory minimum that these cases take at least 91 days, but I generally tell people it's going to be probably closer to a year, maybe even a little bit longer. So gear up and make sure that you're ready for that time commitment if you're filing for one of those two cases. This was a pretty short summary of what goes on in a divorce and custody case. So if you're seeking more information and a little more detail, please feel free to reach out to our program, Family Tree's Legal Advocacy Program, either at 303-271-6559 or at our email at legaladvocates@thefamilytree.org. Thanks so much and hope you're having a good rest of your day.